I've decided to leave the bench. Try my hand at litigation.
It's a good choice when you're blackmailing people as a judge, leave the bench. However, if you're actually blackmailing people like we're seeing here, you're not just going to leave the bench, you're going to lose your license to practice law completely. Hey, it's Jeremy with Civitas Law Group reviewing Suits Episode 2 today.
I don't know how to file a patent.
Figure it out.
Can't we do that after?
No, and you keep talking, I'm gonna start billing you, and my time runs $1,000 an hour.
But isn't this our time, Mr. Hand?
I stand corrected. Your Fast Times at Ridgemont High quote, that proves you belong at the adult table.
Hey, that's a great movie, and it spoke to a generation.
So we're about 2 minutes into Suits Episode 2, and we already have a small issue. Could be an issue, could go either way, and I'll tell you why. Harvey's telling Mike to go figure out how to file a patent. That's totally real. Mike doesn't know how to file a patent, but it has nothing to do whatsoever with the fact that he didn't go to law school. It has everything to do with the fact that patent law is actually not taught in law school, and it's an additional bar exam. Let me correct, it could be taught in law school. It's not required for the bar exam. To be a patent lawyer or to practice before the patent office, you have to have a bachelor's degree related to some field of science and go and take an additional exam to actually be able to practice in the patent office. So that's totally real. Mike doesn't know how to file a patent because most attorneys don't. Now, here's what might not be so real about it. A lot of attorneys may still know how to do that, even if they're not actually admitted to practice in the patent office. The reason is, it could be that Mike here goes and does all the paperwork, and then Harvey, maybe he is licensed to work in the patent office, and he just has a look at everything that Mike did and signs off on it and files the patent himself. That kind of thing happens all the time. It's more the associate senior attorney relationship or even the paralegal attorney relationship. This person does a whole lot of the work, the other person reviews it and signs off on it and submits it. But the fact that Mike doesn't know how to do this has nothing to do with the fact that he didn't go to law school.
Let the record show the counsel is fined $1,000 for failing to follow the posted rules of the court.
So Harvey walks into the courtroom with his phone in his hand, and the judge sees it and says he's fined $1,000 for having his phone in the courtroom, or at least having it in his possession, whatever it was he just said. Now, you might look at that and go, oh, nobody's ever going to do that. And you might already be familiar with this and know this judge already hates Harvey. But I have actually seen, I've been in a courtroom once where a phone rang and nobody would take responsibility for it. The courtroom was totally packed full. And the judge said, okay, everybody out, go put your cell phones in your cars, do not come back in with them. And just stopped court in a very, very busy courtroom for about 20, 30 minutes to allow everybody to go out to the car, put the phone away, pass security again, and get back into the courtroom. So there are judges that actually hate having phones in their courtroom that much.
And I would have assumed that a lawyer appearing before a judge would come on time with his mouth shut and prepared with a courtesy brief.
That's 100% real. Okay, so everybody has a last minute filing sometimes. It could just be a simple motion to continue, or it could even be the reason you're there. If it's an emergency like they're presenting that this situation is, he has an injunction, so that's a request to the court to stop something right now. We have to stop this action from happening. In this case, you better be there early. You better have copies. Probably the clerks, the bailiffs, maybe they're all going to want a copy so that they can actually follow along. They can make notes on it so that they can know exactly what the judge said. So you're probably going to show up with 8 or 9 copies just to make sure everybody has what they need. The other side is also going to want a copy. So for the judge to actually be this surprised and upset and even a little bit rude about it, not that surprising. That's pretty legit.
I have a solid argument for any reasonable judge to grant my injunction. So solid, it begs the question, why do you have it in for me? And I don't even know your first name.
Really? My wife never mentioned it?
Your wife?
The woman you had an affair with last month?
Okay, very dramatic. All right, so here's the issue with that whole conversation. That's what's called an ex parte communication with the judge. And it essentially means only one party is there for this conversation that mostly only regards, why did you call me by my first name? Which maybe you could get away with because that doesn't actually have to do with the case or anything. But the fact that Harvey actually brings in, my injunction was solid and I've got a great argument for it and you should grant it, that brings it back to the case that they were just talking about, and the judge is never going to have a communication about that without the other party present. Also, just as a fun side note, if this judge actually knew or even suspected that Harvey had an affair with his wife, he needs to recuse himself. He's clearly prejudiced against Harvey and he can't rule on this case fairly.
15, that's as high as I'll go.
Okay, I'm hanging up now.
20 million, that's it. Offer's good for 24 hours, and I'm sure I don't have to remind you that you're legally required to present this to your client.
So he's referencing a real rule here. If somebody, technically speaking, Harvey actually had to take the $10 million offer to his client. Harvey rejects it, the guy goes 15, rejects that, he goes to 20. Now theoretically, you could actually have a conversation like that, but since the $10 million offer was an actual offer of settlement, Harvey has to take that offer to his client, unless he's already had a conversation with his client wherein his client has said, I won't settle for anything less than X. So if Harvey already knew that 10 million wasn't going to cut it, and his client has already told him that, and I believe that rule actually states that it has to be in writing, then Harvey has to take that first offer to his client and then call the other guy and say, no, offer rejected. Conversations don't always go that way. A lot of times you go, well, I'll take that to my client, but can you do any better than that? And sometimes you'll get them up to a better figure in that one conversation. But talking about in terms of $5 million at a time, probably not. But of course, I don't practice big corporate law like this, so I'm not usually talking about $20 million at a time or $5 million at a time. So hey, maybe in some New York skyscraper, maybe a conversation really does happen like that.
I've decided to leave the bench. Try my hand at litigation.
It's a good choice when you're blackmailing people as a judge, leave the bench. However, if you're actually blackmailing people like we're seeing here, you're not just going to leave the bench, you're going to lose your license to practice law completely. So you better be having your eyes on something like, financial planning or something, whatever, that doesn't involve a law license, because he's going to lose it if that goes public.
I'm listening.
You sign a document that says you slept with my wife, I'll give you your injunction.
And why would you want me to do that?
To prevent her from taking me for half of everything I own.
Okay, so just in case it's not clear, the judge says, yeah, hey, clearly I'm blackmailing you and using my position as a judge to get that accomplished. So, he's going to not just leave the bench, he's going to leave the bar too. But then he says something very interesting. Why would he want Harvey to sign this document saying that Harvey slept with the judge's wife? Because it's going to prevent her from taking half of everything I own. Well, look, I don't know New York law, but I'm pretty sure that's not the case. Here in Arizona, that's not the case. Infidelity is not actually something that is a major contributing factor to how assets are divided in a divorce. Typically speaking, a judge is just required to distribute assets equitably, which doesn't mean equal, but equitably. And that's pretty much it. Now, it could be a factor for child care issues, and child care can affect child support, and therefore, yeah, it can have some financial impact, but taking half of everything he's got, that infidelity is not going to do that. Pretty much the only time that it's going to have any serious impact on distribution of assets is going to be if one of those parties has actually spent a lot of money or liquidated an asset and spent it on the affair. So in other words, if one of these people has said, okay, I'm going to sell off that rental property and I'm going to use that money to be a little sugar daddy to, this person that I'm having an affair with, that's going to be considered for this distribution of assets. But aside from something like that extreme, yeah, that's not really coming into play, at least not in most states that I've looked at, and definitely not in Arizona.
I'm saying we could both benefit. And since you're the one who screwed me, I'd say you owe me one.
How do you accuse him of screwing his wife, not him? That's weird.
But I knew you'd never believe me, so I kept my mouth shut. But now that she's getting a divorce, my policy no longer applies.
So the show finishes off with something real and something not so real. The third ex parte communication between both of these guys. Now granted, this time they're not really discussing the case, so yeah, this could happen. They're not in the judge's chambers, so there's some factors that say, yeah, that might happen, but it is an ex parte communication. But here Harvey says, you know what, I'm having you investigated, which surprises the judge for some reason because it really shouldn't. Really, Harvey's got him here. Harvey can totally, ruin his life for the most part. This guy could be facing a lot of really heavy penalties and things for trying to blackmail Harvey from the bench. So not surprising that the communication and that this conversation goes the way that it did. Just surprising that for the third time in the show, they're choosing to meet together without opposing counsel present. This one's a little more real, though. Now, since we're at the end, I'll tell you, a lot of people have asked me so far, well, hey, how come you didn't discuss this issue? All the way through this, we had patent issues, we had big corporate law issues. Yeah, because I don't practice those things. I don't know very much about those things. I know hardly any about family law. I knew this. But a lot of people think attorneys are going to know all of these issues because they're an attorney, right? You have an attorney in your family, so you call him and say, hey, I got charged with a DUI. And he says, yeah, but I actually practice contract law. Yeah, he doesn't know anything about those things. So that's why I don't do a whole lot of commenting on the corporate mergers and all the stuff that happens in Suits and other shows like that because, not every attorney knows that stuff. In fact, very few do. All right, well, that's Suits episode 2. Hope you enjoyed it, and we look forward to seeing you next time.